Hello, good afternoon, and welcome to this week's Facebook Live session. Now, we've had some really good sessions over the last few weeks, and as I always do at the beginning of these sessions, if anybody would like any further information from us, any further advice from us, something that doesn't get covered in today's session, we've got a way in which you can do that. We've got a telephone number and we've got a website as well. So the telephone number, if you want anything further from us, 0800 046 3179. Call us up there if you want any further advice, if you'd like to talk to us about anything we can do to help with any of the things that we go through and we discuss today and how we'd like you to come into your business and help with that. That's no problem. And also the website is krona.co.uk/FB Live. Now, as we go through the session, what would be great is if people could just, as we usually do, could pop questions into the comments box for us. That would help. And what we'll do is I'll go through some key updates that have happened over the last week. I'll talk about some questions which we didn't get a chance to answer last week. I'll pool them together and go through them FAQs. And then we'll just move into, as we usually do, an open Q&A session where please feel free to ask me any questions you want. So what would be nice is if for now you pop your questions in the comments box, and if you could like the video as well, if you could share the video as well so as many people can get on this as possible, that'd be great. Really appreciate that. So first thing I'll go through is the changes that have happened over the last week. So we've had three really big updates that have happened over the last week, and the first one I want to go through was the address by the Prime Minister, which came out yesterday about what changes there were going to be. And what they said was that there was going to be significant changes that are going to be happening, and four real key changes that are coming in. Now, just bear in mind that everything is going to be as it is for now up until the 4th of July, but these are the changes that are going to be coming in on the 4th of July. So the first one, I'm sure everybody saw this in the press, was that the 2 metre rule is going to change to 1 metre. So this doesn't mean that it's just 1 metre, that what was said was where it's not possible to stay 2 metres apart, people should keep distance of 1 metre plus. Now, this is one that I think is really key, really important. This was one of the biggest ones, and I've spoke about this rule in previous weeks. I've spoke about the fact that while certain businesses in non-essential retail, for example, got the green light to open, they couldn't open because they couldn't adhere to a 2 metre rule. A small shop, for example, couldn't adhere to a 2 metre rule. So that 1 metre rule gives those businesses who even had the green light to open that ability to now open safely. So that one was really important, 2 metres to 1 metre rule. Another thing to think about there from your business is think about the risk assessment that you've done. If you've done a risk assessment before, which is 2 metres, and 2 metres is fine, you can stay to that, then you can stay with that. However, if you want to get more people in the building, you're thinking about that, whether that's members of staff, whether that's customers, well, you need to think about another risk assessment. The 2 metre one isn't fit anymore. You need to think about one that covers 1 metre now. Another thing that was announced was from a health and safety perspective, what businesses are being asked to do with this new 1 metre rule. So I've just listed a few here that I'll just reel off that were really key points that came up. Avoid face-to-face seating by changing office layouts, reduce the number of people in enclosed spaces, improve ventilation, use protective screens and face coverings, closing non-essential social spaces like a canteen, a communal area, something like that, provide hand sanitizers, and for me, the most important one on here, change shift patterns so that staff can work in set teams. And this is something that I've spoke about in previous weeks, and something that's going to be really important when you come to the flexible furlough scheme, and how certain teams and certain members can come in for certain parts of the week. And I'm sure I'm going to get asked a lot of questions about how that flexible scheme works today. That's absolutely no problem. Just pop in any questions you want and I'll get round to them. But that's something to consider about these new ways of working, the ways in which we need to be thinking about teams working together like that. One really key one was that hospitality can open. So pubs, restaurants, etc. Hairdressers can open now, which for me is one that I've personally been looking forward to. I was straight on the phone to my hairdresser to get myself booked in. I'm in on the 4th. So there are, though, a list of businesses that can't open. I mean, one I was expecting to open with hairdressers was beauty salons, but they're on the list of ones that can't. So I've got a list here of some key ones, 10 key ones that can't open. So nightclubs, casinos, bowling alleys and indoor skating, indoor play areas, spas, nail and beauty salons, massage, tattoo and piercing parlours, gyms and dance studios, swimming pools and water parks and exhibitions and conference centres. So those are the ones that, as of now, we don't have a date for yet. And those are businesses which some were expecting to be able to open on the 4th and now need to think about what their options are. And some businesses are coming to us now and talking a little bit more about the redundancy option as well, and whether or not that's something they want to think about. So that was the third one we went through. And the last one was that 2 households of any size will be able to meet indoors, outdoors, and stay overnight. So this doesn't have to be the same households either, but these households would be able to have to maintain social distancing unless they're in a support bubble. So think about how that works, and that may have an effect on childcare and childcare options for people within your business as well. I'm sure we'll get asked questions about that today. They were the real key things that came up, but I just want to say that for Scotland, Wales, Northern Ireland, 2 metre rule going down to 1 metre doesn't apply there. That's just for England. Okay, so they were the updates from the PM's address that I wanted to go through. I thought they were really important. Another update, really key one, was a change to shielding, which has happened over the last week. So if you're in the critically vulnerable category, the employees were asked to shield. You get a letter from the doctor, letter from NHS that comes out, and you had employees who were shielding. So 2.2 million people have been in that shielding category. And from the 1st of August, they'll no longer need to shield. So that's been made clear. And also, as of the 6th of July, those who are shielding and live alone in England, including single parents who are shielding, they'll be able to create a support bubble with one other household of any size. So for me, this is a really important change, because what's happening in a lot of businesses we're talking to now is they have employees who they want to come back to work. They don't have the ability to work from home, but the employees are shielding. Well, those categories are getting relaxed now, and those are changing. It's happening in turn with the amount of new cases and deaths that are coming down as well. So extremely vulnerable people who are most at risk from becoming ill from coronavirus will no longer need to shield in England, and this means they can return to work if they can't work from home. And the key to this is as long as the workplace is COVID secure. And this is something that I've said on these sessions every week when I'm talking and I'm advising businesses, is that the first, second, and third thing you need to make sure is done is that your workplace is COVID secure. You have an obligation to your employees to make sure that's done. And if the HSE are involved and they come in and do an audit, rightly so, they can come in and they can impose fines, and even worse for the business as well. So we need to make sure that is COVID secure. So that's another key update for shielding. And then the last key update that I had before I get to some FAQs was something which came out from the HMRC. So if I can just reiterate to everybody who's on now, pop into the comments box there any questions that you've got, anything you want me to ask, anything that comes up from this information I'm going through at the beginning, anything you want to ask about your business. And if you could share this video as well, just while we're doing this live, that'd be really appreciated from me as well. So one of the things, the updates that we got last week, was the chief exec of the HMRC called the Coronavirus Job Retention Scheme a magnet for fraudsters. Now, this is something that we've thought about from the start of this, and a lot of questions I've had have been around about this, that this is a scheme which is potentially open to abuse. And this is something that the HMRC, rightly so, are going to be looking at. So what he spoke about, though, which I thought was really interesting, was that if an employee reported their employer to the HMRC, and this would be when the employers going to HMRC and saying, essentially, we've heard a lot of stories about this, I've been working while I've been on furlough. So if the employee goes to the HMRC and says, I've been working while I'm on furlough, what the HMRC have said is that they could investigate that without involving the employer. So they could look at the PAYE, they could look at the pay-as-you-earn system, see if that employee's been paid, and they could obtain evidence from that employee that they've been working during that period. Only after that would they need to contact the employer, and think about this, it's a criminal charge, carries up to 10 years in prison, significant fines as well. So this was one thing that I thought was really worth raising here. I thought this was really important, because this is firmly an employment law issue as well. This isn't just a tax issue, it's an employment law issue that businesses need to make sure, and that's why I'm here, I'll answer questions about this, but businesses need to make sure that they get the rules of this new scheme right, that they claim correctly under this scheme. They don't overclaim for things they shouldn't be claiming for. And with this, I would like to think this is usually not fraudulent, that this is erroneous, that they don't fully understand how the scheme works, especially with the new flexible scheme and how that scheme works, and that businesses are overclaiming under that scheme, or they have employees who are working when a period they're claiming for as well. Well, this is something that the HMRC are going to be looking at. And one of the things that I thought was really interesting on this were that as of last week, I think this was about mid last week, these numbers came out, that 3,000 issues have already been raised for investigation by employees to the HMRC. So I thought that was a really interesting point to go through as well. Just to reiterate, to make sure to businesses that there are ramifications if you get this wrong. So I've got 4 questions that we got asked from last week, which I've pulled together and I'll deal with now, and then we'll jump into an open Q&A session. I'll run through everybody's questions there. So one of the first ones that we had was a question to say that we've just negotiated temporary contract changes to pay the lower salaries from the 1st of July to try and avoid redundancies. How will this work with claiming under the job retention scheme? I cannot find specific guidance on this. We'll still have to pay the original salary for their hours worked and claim the original 80% back, or will this be lowered to their new salaries level? So, always think, and when I talk about these questions every week, that the job retention scheme did not supersede employment law. It didn't come in and wipe out employment law. That we can still agree things with employees as we could agree with them before. We can agree with them to reduce their holiday allowance as long as it doesn't go below the statutory minimum. We can agree with them to reduce the rate they get paid as long as it doesn't go below national minimum wage. So those are things that we can agree with a contract. You have offer, you have acceptance in that situation. And that's how that works. So you can still agree things with employees. The thing then is, what can you claim back under the job retention scheme? That's the new thing. So the job retention scheme is crystal clear that what an employee gets paid is 80% of their salary. 80% of their salary is exactly as it gets paid throughout the period that we're going to go through now, where what they can claim back under that scheme is diminishing. So that might be diminishing for what the employer can claim back, but what the employee gets in their paycheck isn't changing. They're still getting 80% of their salary. So what this question is, though, and this is a really interesting question because a few businesses have asked us this, is, well, I'm going to struggle to pay that. Could I agree with the employee that this scheme covers 80% of their salary? Can I agree to reduce that salary from 100% of that salary down to 80% of the salary, and then claim 80% of that reduced salary back under the scheme? Now, there's nothing in the scheme that says that you can't do that. There's nothing in the scheme that says you can't agree to reduce somebody's salary, that there's no fluctuations in pay over any window that they're on furlough. There's nothing to say that. Might be something that is dealt with later on, and that might be something that HMRC picks up on to say that that is not in the spirit of the scheme. The spirit of the scheme was to keep the level of wages the same as they were for these employees throughout the scheme, and that might be something that they look at to say that that was not in the spirit of the scheme, and therefore might have an issue with what you can claim back. Because what is clear about the scheme is that you have to pay the employees 80%. If you pay the employees 79% of their salary, you can't claim anything back under the scheme. You have to pay them a minimum of 80% to make a claim under that scheme. And they may see that this was a manufactured situation to reduce what was paid to the employee. But there's nothing under the scheme which says that that can't be done at the moment, but that's something I'd be cautious of if I did go and do that and have that agreement with the employees. Now, if you are going to agree to reduce someone's salary, there's a process for doing that. There's an offer of doing that. They accept that. You go through that process with the employee, and then the scheme says that they're paid 80% of their salary. So if their salary was lower, you would claim back 80% of that salary. But what you couldn't do is reduce their salary by 80% and claim back the entire salary. You couldn't do that. So if you're reducing the salary by 80%, you wouldn't be that much better off as a business, because you'd be reducing what they get paid by 80%, but what you could claim would be reducing by 20% as well. So that's something you need to consider, that what you couldn't do is reduce it and then claim that full amount. You couldn't do that. So I hope that answers that question. That was the first one that we had. The second one was, at present, we have some employees that are on furlough and receiving 80% of their salary. For the employees who are not on furlough, so you've got some employees who are working, fine. We've not reduced their salary, but we've reduced their hours. So they also receive 80% to make it as fair as possible for everyone. So they're getting paid full pay, but just for the hours that they work, which are 80%. With flexible furlough, if an employee is working part-time, how would we have to pay them? How would we have to pay them their full wages for the hours that they work? How can we make it fair for all employees to receive 80%? If we gave flexible furlough as a pay cut, this would mean that we wouldn't be able to claim as much into the scheme as their salary is lower. Okay, so some really interesting points there. The first point that I would go through is how you agreed the 80%, or how you gave the employees 80% of their hours. If I'm on 100% of my pay, but my hours are reduced by 80%, my employer needs to agree that with me, unless my contract allows for that. If I've got a contract which has a variation or flexible hours clause or something like that, which allows my employer to give me a variety of hours each week, and I just choose as an employer to give 80% of those hours, that's fine. So it depends what's in the contract to cover that, just to make sure whether that bit was done right. We can't just tell employees that they're now doing 80% of their hours unless something in the contract allows us to do that. So let's say, for example, in this situation that the contract does allow us to do that, and we are allowed to reduce their hours down to 80%, and we've done that. That's fine. When we get to the new flexible furlough scheme, and employees working part-time, they get paid full pay for the hours that they work, and they get paid 80% of the pay for the time they're on furlough. And what I would do is just look at balancing that between the two, and how you work that with the reduced hours to make sure that was fair. So I hope that helps on those two. Just another couple of questions that I had, and like I said before, just please feel free to tap into the comments section any questions that you've got, and I'll move on to them as well. So another question we had are, what are the options if an employee refuses to return under the new flexible scheme? Now, this is a really common question that we've been getting asked as a business by our clients. This is a really commonly advised upon area. Is you have a business now where, I saw something, wouldn't have been this weekend, the weekend before, I think it was from the Highways Agency, which said that 75% of traffic on the roads was back from as it was pre-COVID levels, and that they anticipated by the end of June would be back to 100. I don't know those up-to-date numbers, but I would estimate that now, from where those numbers looked, from just anecdotally myself traveling into work, I would think those numbers will be pretty much back up to 100% now. Certainly looking like that from the 4th as well, with all the new ones that I announced opening up. But non-essential retail was a key, and I said that that'll be like a lights on for the economy as well. And that was something that we saw in public transport and travel and things like that, something businesses need to consider as well. And what we're getting is that a lot of businesses are coming back now, but some of the employees are saying, well, I'm refusing to return to work. Yeah, we agree I can't work from home, but I just don't feel safe coming into the workplace. And that's a feeling which was with a lot of people, especially people who may have been at home for 3 months and they haven't been out, they haven't been exposed to the workplace, they haven't been exposed to many public places. They may feel apprehension about coming back, and that's understandable. That's something that we as employers need to deal with. What options do you have in that circumstance? So the first thing that I would always be doing with an employee like that is talking to them, seeing if we can get some sort of agreement with the employee, maybe letting them know the risk assessment that we've done, sharing that with them, getting their feedback on that, maybe them speaking to another employee who's back at work and showing them photos or video of that workplace, and just letting them know that the workplace is safe, the workplace is secure, and any fears that they've got would be appeased when they see that. Now, if when they don't see that, they say, no, still don't feel like I want to come back to work, you've got a few options available to you. Now, one of those options is they remain on furlough. Excuse me. One of the options is they remain on furlough. So we can still use the scheme. We can keep them on furlough, but appreciate that the attractiveness of that scheme is going to diminish as of August. So June, July, it's going to be the same. It's going to diminish as of August, September, October. It goes down each month on what we can claim back there. So that's something to consider as a business. And maybe that doesn't work for you either. Maybe you need the person back to fulfill client contracts. Well, if you need somebody back to fulfill client contracts, somebody being on furlough, operationally isn't going to work, despite the employment law question you're getting asked. We spoke last week about maybe bringing in some temporary people to cover childcare with the schools not getting an open date. That's something else you could consider as well, just from an operational perspective. But that's the option. Option one you've got is they stay on furlough. Option two you've got is we agree a period of unpaid leave with them. That we say, okay, it's absolutely fine, you don't want to return to work. We need you back though. We're no longer agreeing to you being furloughed. So if you don't want to be in work, we're going to agree a period of unpaid leave, which for some businesses will think, well, that will give the encouragement that's needed to get people back into work. But need to make sure that option does attract more risk than the furlough option, because it's placing someone in a period of unpaid leave because they've raised issue with the safety of the workplace, something that carries some risk. And bear in mind, this is an unprecedented area for us, that we don't have any cases to help us with this now. But that's something that I would always, when advising a client, just highlight that risk to them. And the third option you could have is you could say, as a business, we have work available for you. The workplace is COVID secure, and we've ensured that was done. That was of paramount importance to us. So we're going to say that you are failing to follow a reasonable management instruction, and we're taking you down a disciplinary route. Now, some businesses that I've spoken to have taken that very option. And while that's a strict measure, to take. They appreciate fully the risk that they have going into that situation, but they feel safe that they've had their risk assessment done. The workplace is COVID secure, and that they're in a position where they can say quite well, I want you to come back to work, and I'd be happy if somebody externally came in and had a look at this workplace and saw what we've done. So they need to appreciate that last option there just attracts more risk. Of course it does if you're going down a disciplinary route. Excuse me. So, and the last question that we had was, do holiday rules remain the same under the new scheme? So this is a question we're getting asked quite a lot about holiday pay and how holiday pay works. Got asked quite a few questions about this last week. I'm sure I'll get asked questions about this week as well. So under the old scheme, you still accrued annual leave while you're on furlough. That was something that we know that worked. People could take annual leave while they're on furlough, and under the working time regulations, we can have someone be required to take annual leave as long as we give them double the notice of the leave they're going to take. Now, all of that was the same under the old scheme. All that's the same under the new scheme. An employee still accrues annual leave. An employee can still take annual leave, and if they take annual leave, we can claim that back under the job retention scheme. Now, I just want to cover this point of it under the new scheme and how that's going to work. So basically, the rules are the same. They accrue leave, they can take leave, we can require them to take leave as long as we give double the notice. One of the things that I do think needs highlighting on this, though, is what if you have an employee, they under the new flexible furlough scheme, they work for you for 3 days a week, and you pay them 100% for those 3 days a week, and for 2 days a week they're furloughed, and you claim back for that under the job retention scheme for the 2 days that they're furloughed. Next week they say, okay, I want to take full week off as annual leave. Well, what do you claim back under the job retention scheme? It's definitely the 2 days. If they want to take 2 days of annual leave where they're usually furloughed anyway, they would just be taking leave on those days. That's fine. They're furloughed for that time. We pay them 100%. We can claim back whatever the diminishing rate is, 80% at the moment, but we claim that back under the scheme. So those 2 days, pretty straightforward. Would the employee want to take leave on the furlough days? Or are they just going to request, I'd like Monday, Tuesday, Wednesday off, please, because I'm furloughed on Thursday, Friday anyway. So they might not request those days. So, but again, we have the ability to require them to take days. And the question is more about the Monday, Tuesday, Wednesday. So on the Monday, Tuesday, Wednesday, what's the situation there? Now, there's nothing under the scheme which says that if people have fluctuating hours and fluctuating ways they work, that if somebody is moved onto a day on furlough on that day because they've requested annual leave, there's nothing that says that that's not allowed, that stops that. However, I would go with caution on that, because I'd think about always looking at something that's new, a new piece of legislation. I always think about the spirit in which that new piece of guidance, that new piece of legislation is written, and how that's going to be enforced later down the line. And I don't think the spirit of the new guidance is that if I've got an employee who works Monday, Tuesday, Wednesday, that if they say I want to take holiday Monday, Tuesday, Wednesday, that I would then claim that back under the scheme, put them on furlough and claim that back under the scheme. But my point is that there's nothing on the scheme which says you can't do that. So that was a question we got asked quite a lot. And the thing with this is, a lot of this is brand new. Businesses need to make the decision they've got with the information at hand, and that's how we guide them. But they do need to appreciate certain options attract a certain level of risk, and some of the risk isn't quite clear yet, but you can see at early stages about how something was designed and how it was set to work. And as we saw with the Treasury direction, as we saw with the guidance initially, those pieces of documentation and guidance for us evolved over time. They gave more clarity to us. And it was only further on that we realised certain things could or couldn't be done. And I think it will be exactly the same with what can be claimed back under the new scheme. And it's only as people bring things up and try things that we get further clarification on those matters. So in simple terms, the example I gave before, for those 2 days that they take off where they were furloughed anyway, they would get 100% for those days. If they want to take them as leave, we would claim back 80 and they would use up 2 days of leave. For the Monday, Tuesday, Wednesday, if they were working those days anyway, yep, they would use them as annual leave. That's absolutely fine. The question is whether or not you would say on that period, can we agree for that period then that you furloughed? We'll furlough you for those 3 days and claim that back under the scheme. Nothing that says you can't do that, but I would approach that with caution. That would be my advice on that. So if we move on to questions now, like I said, anyone who's got any questions whatsoever, just pop them in the comments. And if it would be great as well if you could just like the video, if you could share the video so we get as many people on here as possible and get as many questions going as possible as well. Okay, I'm just looking through here for something that's not been covered in the points I've gone through in the beginning. Okay, so there's a question here. This is about shielding employees. So, can I still furlough an employee who is looking after a shielded patient on chemo? We're open in July and there's work for this employee. So, yeah, there's no requirement at the moment that anything in the rules say that there has to be a redundancy situation in their role. So we don't need that. The only thing I would say is that under the new scheme, they have to have been furloughed under the old scheme to be able to use the new scheme for at least 3 weeks under the old scheme, or they can't just use the new scheme. They need to essentially kind of be on the register to use the new scheme. So, yeah, we can still furlough that employee who's came someone who's shielding. Okay, yeah, we can do that. Okay, so we want to bring a furlough employee out of furlough from the 1st of July, but we want them to do their full hours. They work 16 hours a week. That's absolutely fine. Just before I move any further, that is fine. As long as they were furloughed for a period of 3 weeks, you can bring them back under the new scheme. And well, if we bring them back full time, that doesn't matter. If you wanted to take them off again to be able to claim, you'd have to do that. So yeah, if we've got somebody on furlough who wants to bring them back, we can bring them back on their full hours. That's fine. It doesn't have to be part hours. Under the old rules, we had to write them a letter bringing them out of furlough. What's the advice now? Do we write a letter, or can we do this via email or call them back to work? Not sure how many weeks we need them for, but they would at some point go back on furlough under the new scheme. If they do go back on furlough, then do we need another agreement from them and we're placing them on furlough? This is a really good question, and this is one that we're getting asked quite a bit, is when we did it before under the old furlough rules, it was simple. They could not work at all. No work whatsoever. That breached the rules. So it was simple. We got agreement from them. We sent them a letter and they went off on furlough. They went home. We had no contact with them. And that was it. The employee was on furlough. So that was the end of the situation. Really simple, really straightforward. We had to get their agreement to come on furlough. And then if we were going to bring them back, we'd speak to them. We would get their agreement. They would come back off furlough and we'd have them return to work. That's quite straightforward. I think that the thing that a lot of people are asking about now is the new scheme is a lot more complicated. It's a lot more complicated under the new scheme about exactly what's going to happen with those employees who we want to bring back part-time, and primarily how we evidence that we've got that agreement from them as well. So what we don't want to be doing as businesses is thinking, well, I've got an employee and next week I need her for 2 days, the week after I need her for the full 5, the week after that 1, and every week writing to the employee and obtaining an agreement for them to work those certain days each week. That's something that practically as a business you don't want to be doing. So we've got them on furlough at the moment in this example that we're going through. And one thing we need to do is we need to speak to them. That's the first port of call I would do. I would call them. I would talk to them. I would explain to them what we want to do and how we want that to work. At the moment, we do need you back for your full-time hours. That's going to fluctuate over the next few weeks. And what we need to do is work with you on that, but gain your agreement from you that you're okay with that, of us changing the hours. And this is the process of how we're going to notify you of those hours. This is what we expect that to look like. They'll want to agree how that's going to look. And then I would obtain their agreement that we can offer them those hours in a week and they have an obligation to accept those hours. And for the hours they don't work, they agree that they're going to be furloughed and that we'll dictate those hours to them each week. So we can send out a rota to them. We can explain what their hours are, but we've got an overarching agreement that for the hours they're not working, they're agreeing that they're going to be furloughed. And that means we don't have to keep revisiting them all the time when we change those hours. So I hope that helps with that point. Okay, so another question: employees who are on furlough and have been paid 80 to 100% allowed to work privately to carry out jobs at home, meaning earning and not paying taxes, etc. So an employee who is furloughed can go and do other work as long as their contract doesn't prohibit it. So it wouldn't be right if you had a new contract that they couldn't work for a competitor. You put them on furlough and all of a sudden you see them popping up at the competitor. But the contract prohibits that. But they are allowed to go and seek other work. That's fine as long as it's not for you or for a company that's associated with you. So you're having them on furlough, but really they're working for you in another way, or doing other duties or something like that. Anything which provides service or generates revenue for your business. But yeah, they can go and work elsewhere as well. Okay, Paul, so we've got a couple of staff members coming to the end of their shielding period in the next few days. Can they return to work earlier than the 1st of August? Yeah, they can. It just depends what the terms of their shielding period are, about what their health condition is. If they're employees who are still being told by the doctor, still being told by the NHS that they should be shielded and they shouldn't be in work, then that's something that we need to look at holding off on, depending on their individual circumstances and what the workplace is like. But if they're saying that that's come to an end and they're fine to come back, then we can agree that with them as long as we've got everything in place and ensure that that's secure. Okay, Wendy, this is a really interesting question. So, at what point could we have a discussion with the employee who doesn't want to come back? That the possibility could be redundancy. Now, first of all, let me just unpick this a little bit. So, you've got an employee who we're saying, okay, we're ready for you to come back. We've got plenty of work for you. We want you to come back to the workplace. And they say, I don't want to come back because I don't feel safe at work. Well, the question is what we do then. I talked before about a few options you've got: keep them on furlough, unpaid leave, and take them down a conduct route, disciplinary. So they're the options that we've got available to us. The question you've got here is, at what point can I consider redundancy for them? Well, first of all, to consider redundancy, you need to have a redundancy situation. You need to have a diminution or cessation of work, a particular kind, of particular site. There's a qualification for redundancy that needs to be satisfied before we can say we're going to look at a possibility of redundancy for this role. So if we're in a position where we have a lot of work and we need them back to work, that's a position where we're saying, well, that might not be a redundancy situation. So that's what you've got to think about first. No issue with redundancy, no issue with making employees redundant and claiming the notice pay back under the job retention scheme. There's nothing that says we can't do that. One thing that I was always speaking about quite a few weeks ago was that there's a suitable alternative to redundancy available at the moment that employers need to consider, and that's the job retention scheme. However, before we were paying 80% and we were claiming back 80%, it's a very attractive option for a business in that situation. When we get to the point where we can't claim back pension national insurance, where we can't claim back the full 80%, that's going down to 70 and then 60, this becomes a significantly less attractive option for businesses, which leads to believe that that is not as suitable an alternative to redundancy as it appeared to be before. So that's something to consider as well. But first port of call there, we need a genuine redundancy situation to be able to do that. So if we are in a situation where, say for example, we've got an employee who we want to put on the new flexible furlough scheme, and they say, I don't want to do that, and we say, we don't have enough work for you, in that situation, we could weigh that up as a redundancy situation, because what you're looking at there is we don't have enough work for that role. There's a diminution in the amount of work we need for that role. So we want them to take a period of furlough. They don't agree to that because they don't have to. They don't agree to that. It will be then that I'll be discussing a redundancy situation with them as well. So I hope that helps. Okay, so a question here about, can we claim 80% of the furlough employee's holiday pay from the furlough grant? There's nothing in the scheme that says we can't do that. Saying there, Hina, that you've got information to say that you've been advised that a colleague's been advised that that claim can't be made under the job retention scheme. There's nothing that says that holiday pay the holiday pay can't be claimed back under the scheme. In fact, there's specific government guidance on that exact point as well. So if an employee is on holiday in that period and we enforce holiday onto them, then that wouldn't mean that the claim back under the job retention scheme would pause for that period of time or diminish. The employee would get 100%, and essentially the business would pay 20% of that holiday, because they could claim 80% of it back under the job retention scheme. Okay, Pretty, I have a question here. So what if a staff member has been shielding and they don't want to return to work on the 1st of August, which I think will be, personally, I think this will be quite common. Where do you stand as an employer? So there's a few options available in this situation. You need to think, first of all, about the type of employee that you're dealing with, the condition that they've got, that the likelihood is in this situation the employer will probably qualify under the Equality Act as a disabled individual. That might not be the case. Just need to make sure that we've got that established first. But you've got a few options available to you. So first thing is August. We've still got August, September, October. We could furlough them. We could leave them on furlough. We could claim for them the job retention scheme, but at that diminishing rate, as long as they've been on furlough before. So we can keep them on furlough. You might have the option of them working from home. That's something you need to consider as well. They might be able to do that work from home. And like I spoke about before, the option of unpaid leave and maybe taking them through disciplinary, maybe through conduct as well. So there's a few options available, just certain ones which track to a certain level of risk as well. And that's something that I think we need to make sure that is dealt with when we're dealing with anyone coming back from a period of shielding, because they may have been at home subject to a different environment to people who weren't shielding, that they weren't going out at all, they weren't going in public areas, that they were much more based within their house and not going out maybe at all. Then say after a few months, great, we'll see you back in the workplace. That might be something that I think will be very common for a few employers. So that's just another point to think about as well. And one thing that I would always do in that situation is make sure that I communicated really clearly to them about how safe the workplace is. I would make sure it was COVID secure. I would make sure the workplace was safe. I would make sure that I'd done my risk assessments. I had professional help with that, and that was all done. I know I'd be in a really nice position then to communicate that with them and explain to them, this is what it's going to look like when you get back to work. There's no danger here. You're going to be fine. And that would be the first port of call for me to explain that with the employee. Okay, so another question to say, now that the government has advised that other households can help with childcare, so we've got bubbles now, which I spoke about last week, is the lack of childcare a valid claim for not being able to return to work? Now, with this situation we're in now, it's ever changing every week. The rules are getting relaxed every single week. We're getting new changes every week. And what this means is that an answer that I would have given to these questions 2, 3, 4, 5 weeks ago, it's a completely different answer today, because the rules are relaxing and the rules are changing every single week. And I think that the same can be said for the conversations that we've had with employees. If we have a conversation with an employee 3, 4 weeks ago, or we've dealt with that issue, well, the situation's evolved since then. And as the situation evolves, I think it's right to revisit those conversations, to go back to those employees and have that conversation again and see if there are any other options available to them now. And one of them, really importantly raised here, is about childcare. And if somebody's in a bubble with somebody else, or somebody can now, on the 4th of July, they can stay over at somebody else's house, they can see grandparents, things like that. Does that affect the childcare situation? Does that mean that people have more options, which means that if they couldn't return to work because of childcare, those options have changed now? And we know from the situation that certain years aren't going to be coming back until September. Well, 2.5 months, it's not going to work for some businesses. So in those situations, people need to be thinking about childcare and about whether there are any other options we can look at. So I think the right thing to do is to speak to these employees, to just revisit these conversations and see if there's any other options they've got available, any other solutions they've got, which mean that other child can be arranged and they can come back to work. But that's a really important point as well. Okay, Alina, this is a really interesting question because I've been getting asked this question a lot. And I think this is probably me not explaining this clear enough, so I'll explain this one again. So if an employee goes to part-time, we know we've got the new part-time furlough scheme coming up, and like I said before, Employee works 3 days a week, they're furloughed for 2, they're coming back to work part-time. So if an employee goes to part-time and the rest on furlough, would their accrued holiday pay be prorated? No. They accrue their holiday pay at the same rate they would have accrued it before because they're employed for that entire window. It doesn't matter what days they work. Just as under the old scheme, if the employee was furloughed 100% of the time, they still accrue 100% of the annual leave. They accrue exactly the same level of leave as another employee who isn't furloughed. They just accrue leave at the rate of their contract of employment. And that's going to be exactly the same under the new scheme. They accrue leave at the rate of that contract of employment. The only question is about them taking that leave and what qualifies as leave as well. Okay, Claire, this is another question. I don't think I've had this one for a couple of weeks, but this is something that I've answered quite a bit as well. I think I'll set this out in a really clear way. Is that just before lockdown, we had an employee who was on a probationary period, which was coming to an end, and they were not performing. Do we need to extend the probationary period when we return to work? Just take a step back from this because I think I can give an answer which relates to another couple of questions as well, which might not be as specific as this. So, as I said before, the job retention scheme furlough did not in any way change employment law. So employment law sat exactly the same as it did before, and what's happened is a new option has been brought in, and that is an option to put an employee on furlough and claim for that under the coronavirus job retention scheme. So that's the new option that's come in. So what this means is that we can still fail somebody's probation, we can still extend somebody's probation, we can still dismiss an employee for poor performance. Employee still needs 2 years service to be able to claim ordinary unfair dismissal. If they're over that, we need to dismiss them for one of the 5 fair reasons. So all of these rules which apply to unfair dismissal still stand. Contract law still applies, notice pay still applies, processes still apply which are in those contracts. Everything still sits the same as it did before. Now, what I'll be thinking about first of all for an employee on the probationary period, for this example, I'm assuming they're less than 2 years services, they're still in their probation. And if they are, they don't have the right to bring a claim of ordinary unfair dismissal. So as long as there were no issues raised which would give rise to an automatic unfair dismissal, I won't go into the complexity of those now for the purpose of this question. But if there weren't, then it's a relatively straightforward situation for a business. So if we have an employee who we don't think is performing, what we do is we can fail their probation in line with what's under that contract of employment, and that's our decision as a business, what we do with that employee. We also have the option, if we want to extend that probationary period because we don't feel like, because of lockdown and because of furlough, the employee had enough of an opportunity to prove themselves in that role. And we also have the option to pass the probation. We can pass the probationary period. We can pass the probationary period early if it allows us to. So we can do that process as well and move them on to being a full employee. So simply in the answer, that no, you don't have to extend it if you don't want to. If you want to fail it, you can do, as long as the contract allows that. We follow for the contract, and there's nothing that's been brought in from the job retention scheme that would put a blocker on that or change any process that we would have under considering a probationary period for an employee. Okay, Paul, this is a really good question, and I'm not sure that I've been asked this one before, so I'd be really interested to see what people think about this answer as well. So, do we still have to roll over holiday entitlement for the next 2 years? Even though it's reasonably practicable, they can take holiday in the current leave year. Well done on you reading the guidance. We currently have no restrictions on taking leave in the current year. This is a great question. So when the job retention scheme first came out, there was a lack of clarity about whether or not employees could take leave on that, whether we could force them to take leave on that, whether we could claim that back under the scheme. And as lawyers, we were given an educated guess on what we thought that was going to look like, and then thankfully the guidance came out and it clarified it over the weeks as that came through. But what the guidance did say quite early on was that they said that employees can roll over holiday entitlement for the next 2 years, next 2 annual leave years. So if your annual leave year is the calendar year, and that would end at the end of December, they could roll that over to the next year and the next year, any balance that they had in that period. Now, taking a step back and me thinking about what the spirit of that drafting was, I think the spirit of that drafting is for, more than likely, in my opinion, government employees, maybe even people working in the NHS, that for people who might not have the option because of the effect that coronavirus had on the country and the fact that they had to go there, they had to save lives, they had to work in other areas where that was required for this period of time, which didn't give them the ability to take as much leave as they would or exhaust their full entitlement in this year. That would not have been reasonable. But I'm not sure whether that was drafted to apply to a business where the business goes and shuts down for a period of time. And that's why the government came out with further guidance, which says that as a business, we can still, under the working time regulations, require them to take leave. And that's a lot of practice that a lot of our clients have been taking as well, is to say that we want employees to come back from furlough. I mean, you've got to think here, there's a situation where employees might have taken no leave before March, they were furloughed in March, they're furloughed all the way up until the end of October, and they come back and the business is like, right, we're ready to go, we need you back, the job retention scheme's over, obviously back to full-time work, right, we're going, need you for the rest of the year. And they go, okay, I just want to put in a leave request of 5.6 weeks leave over November and December. And then as a business, we have to deal with that request. And Paul makes a really good point as well, to say that you've got employees who will say, well, I just want to roll that over to the next leave year, and I'll take it a big chunk of next summer off as well. I'll do that. I'll have another few months off next summer. So that's something that we need to think about as well. And then the question comes in is, was it reasonably practicable for them to take it within this year? And Paul makes a great point to say his business has no restrictions on taking leave in the current leave year. So is it reasonably practical for them to take it? Now, that is an arguable point. I think best practice would be to have a look at what leave balance your employees have got now, as of today. Have a look at what leave balance they've got now. If you've got employees on furlough, if you've not already done this, I would be looking at the option of requiring them to use up some of that leave while they're on furlough so they don't come back with a big bulk of leave. That's the first thing I'd be thinking about. Ask them to take it first, but think about the easiest thing we might have to do is just require them to take that leave. So we diminish some of that leave balance while they're on furlough, which I think is reasonable, especially the leave they've accrued while they're on furlough. And that's reasonable. And then they come back to a position where they have some leave and we want them to take that over the rest of the year. It might be that as a business, it works for you for them to roll it over to the next year. You have that option as well. But if you've got no restrictions, Paul, and you want them to take it, for one, I'd be encouraging them to take it while they're on furlough if they are. If not, I'd be looking at the leave balances now and saying to them, you need to take this leave before the end of the year. I'd be declaring my position quite early now. With the end of June now, I'll be saying to them that by the time we get to December, you're not going to be rolling this over. As a business, we say it's reasonably practical for you to take it within this leave year. I want this done this year, so you need to start using up your holiday. If you do that in advance, then I think you're in a fine position to say at the end of that year, we gave you the option. There was no restrictions. We didn't reject annual leave that came through. It was reasonably practical to take it in this leave year, and therefore you don't roll it over to the next leave year. And that's what I would be looking at as a business. So I hope that answers that question. But that's a really good point. I'm glad that came up. Okay, Rob. So the question here is, if I'm furloughing from July, does employer contributions go up and how should I process that through the payroll? So just think about this simply, is what we pay to the employee doesn't change. That remains exactly the same. That's the same for June, July, August, September, October, then the scheme ends. And that's the same as it's been throughout. So the employee gets 80% up to £2,500 a month. Okay? That's what they receive. That's what you process through the payroll. That's what they get paid. That never changes. Okay? What does change is what we can claim back from the HMRC under the job retention scheme. That's what's changing. And for that, for June, it's exactly the same. For July, exactly the same. For August, August means that employers' contributions for national insurance and pension, we cannot claim. September, the same, and that carries on August, September, October. But August, you can still claim 80% back. September, that goes down to 70% back. October, that goes down to 60% back. But if you're thinking what you pay through the payroll and how that's going to change, what you pay through the payroll to the employee stays the same. Okay, Tracy. We unfurloughed staff in June, but brought them back on reduced hours. Will we be able to claim On the part-time furlough for the hours they're not working from July onwards, yes, you will. As long as they were furloughed for a period of 3 weeks, they're essentially on the register of that old scheme. And this is something we've seen quite a few businesses do, is that they just couldn't wait till July to get these people back on part-time hours. But they're working part-time hours now, and then they can be furloughed for the rest of the time. I assume that at the moment, if we've agreed with the staff to work part-time hours, they're being paid for part-time hours as well, or they're being paid for the full week and we only need part of the week. Just about what that complexity of that agreement with the employee is and just how that works as well. But they couldn't be agreed to be getting paid for part-time hours and then we're claiming back for the full week under the job retention scheme. We couldn't do that. They'd have to be getting claimed back for the hours that they're engaged under their contracts for, not necessarily working. So Elaine, you've got a question here about where can we get professional help with the risk assessments. We can help you with those risk assessments. I gave a number at the beginning for anybody. It's 0800 046 3179 and it's krona.co.uk/FB Live. So if you want to get in touch, and as I said before, quite a few businesses have. If you want to get in touch for any further help, any further guidance, just give us a call and we'll help you with that. So, Katie, we've got a question here. We've taken on new staff to cover the shielding staff. We might not have work for the ones returning after August, September. Where do we stand? It all depends upon the terms upon which those staff were taken on. If they're short-term staff, which I assume they will be, they'll be short-service staff. Somebody who's got less than 2 years' service. You've got to think they don't have the right to claim unfair dismissal, but we do need to adhere to the contract of employment, which was agreed with those staff. So, just depends on what's in the contract, how those terms work, and we'd remove those employees, and the shielding employees would be able to come back to work and go back to their usual roles. The temporary staff, what we wanted to do with them would be dependent upon what was agreed in the contracts with them. If we wanted them to carry on working in some capacity, if we wanted them to just leave the business, we could do that. It just depends on what's in those contracts. Okay, Nicola, question here. We have a furloughed employee who has resigned and entitled to accrued holiday payment for the past 6 months. Can we reclaim any of the accrued holiday pay from the time on furlough under the job retention scheme? No, would be my answer to that. If you've got an employee who's serving a notice period, they're still employed by you from that period. As long as we follow the rules and they're furloughed for that notice period, then we can reclaim that back under the job retention scheme. There's nothing which exempts that happening. Couldn't do that with pylon though. If you're paying somebody in lieu of notice, it couldn't work because they're not employed for that period. So that situation wouldn't work. That'd be one thing that we'd need to think about. But if you've got accrued but untaken annual leave, and what happens with that is at the end of somebody's employment, any leave that they've accrued but haven't taken, they're paid for in a cash balance. No, we couldn't claim that back under the scheme because that wouldn't be claiming back for days that somebody was furloughed rather than be working. That would be claiming back a sum which signified annual leave which hadn't yet been taken but had been accrued over the rest of the year. Okay, Rob, so if you allowed an employee to take leave, as in Paul's query before, which his query, if you remember, just spoke about if it's not reasonably practicable to take it in the year, then you get to the end of the year, and I explained that the good thing to do would be to contact employees now to look at the leave balance we've got now and say to them that, well, you need to take it before the end of the year because we're not saying you can roll it over to the next year. We're saying it's reasonably practicable to take it in this year, and that was the advice I gave about that before. If you allow them to take leave as per Paul's query, and they don't, does the leave just expire? You don't need to pay them for it. No, you don't. You don't need to pay them for it at the end of the year. You would say that the leave is expired. Now, part of this, though, will depend upon the contract of employment that you have. And I always go back to a contract of employment because it's not the case that it's overarching for every business. A lot of this is based in contract law about the leave year, about how leave rolls over. If leave rolls over, if people get to the end of leave year and they didn't take it, that's something they get paid for. If they have a buyback scheme. So if you can sell annual leave down to your statutory minimum, if you get in excess of statutory minimum, there's all different clauses you see in contracts for how businesses like to run their business and like to reward their employees. Let's take for this example, though, that there is not a clause which says at the end of the year you get paid for it. It's silent on that point, and there isn't a clause which says there's a buyback scheme so you can sell annual leave as well. What would happen is you would get to the end of the leave year and that person's leave balance would just extinguish. So if I had 35 days to take in a year, I work for Paul, and Paul got in touch with me now and he said, Paul would be better. My name's both burnt Paul for this example, but he said to me that you have to use your leave before the end of this year. It's not reasonably practicable. Got that 6 months in advance. I booked a bit of leave, but I didn't take all of it. I still had 5 days left at the end of the year. I would just lose those 5 days, and I would start January with my leave balance again of 35 days. So that's how it would work. I wouldn't be expecting Paul to pay me for those days unless something in the contract said that needed to happen. Okay, Charlotte. Seems like quite a complicated example. Just let me work this through. So I want to pay my manager for 6 shifts. I'm furlough her for 4 shifts. Okay, we've got 10 shifts in total. 6 shifts the manager's on furlough. 6 shifts the manager's working, and 4 shifts they're on furlough. Normal pay is 10 shifts. Is she only entitled to 80% of pay for the 4 furlough shifts, or do I have to top it to 100%? I know we have to pay 100% for the 6 shifts she works. Okay, no, that's quite straightforward, actually. That's a good example. So you've got an employee who you've got 10 shifts for. Straight away, we've got 6 shifts where they're coming into work. They're working for us under this new flexible scheme. Yes, that attracts 100% pay. They get paid 100% of their pay as is outlined in their contracts of employment. And we don't claim any of that back under the job retention scheme. That's just them working for us and us paying them. We've got the other 4, where for those 4, that employee is on furlough. So whatever's been agreed for furlough applies to that employee. If you've agreed for the furlough period, they're paid 80%, they get 80%. If you've agreed with the employee that they get paid 100%, they get paid 100%. What you claim back is 80% of that. So bear in mind that even as the levels of what we can claim back diminish, the employee can never get paid any less than 80%. Otherwise, we as businesses can't use the scheme. So that always needs to say 80%. But yeah, in that example, you would pay them full pay for the time they work, and for the time that they don't work, then that's something they would get paid 80% for if that's what you'd agreed with them. So I think that's everything that we've got time for this week. I just want to thank everybody for coming. I know the weather's really nice outside today, but it's good that so many people have taken the time to come to the session. And like I said before, if anybody wants some more advice from us, they want some more help, the number they can get in touch with us on, it's 0800 046 3179. You've got any more questions, you've got anything more you want to ask, that's absolutely fine to call up there. And the website is kroner.co.uk/FB Live. So that's the end of the session. Had some really good input and some really good questions. So thanks for everything, and we'll see you next week.